Hi everyone, welcome. Welcome to our Board Governance Training Initiative. My name is Todd Kenneth. I'm the Executive Director of Art Services Initiative of Western New York. I'm glad to see so many unfamiliar faces here today, which means that we got some board members out. Normally ASI works with your staff, works with executive directors, artistic directors, and other staff. We do capacity building, collaboration, and advocacy, both for individual artists and organizations in 5 counties in Western New York. That's everything from training sessions like you see here today. We keep abreast of issues at the municipal, county, state, and federal level that might affect organizations. Certainly the Nonprofit Revitalization Act is on everyone's minds right now, but also public funding and policy issues. We do a little bit of programming ourselves. We're the site that administers the New York State Council on the Arts re-grants for area in Niagara County. We're involved in the Buffalo River programming grants, and we're a subcontractor at Canal Side to ensure that cultural and community programming are present at that site as Global Spectrum has been working on programming. So thank you again for coming. I want to thank Melissa Brown and everyone here at the Buffalo History Museum for hosting us this evening. I do want to mention 2 things that are coming down the pipeline that ASI is working on. Number one, we provide all of our services tonight and everything else I mentioned free of charge to those who use our services. And we do that because we really feel that whether you're one of the biggest culturals or a very community-based organization, we want equal access and we want very much for everyone to be at the table. We've got to pay for that somehow, and so we're having a fundraiser on June 25th. But we're calling them the Spark Awards, and it's basically like the old arts awards, cultural awards. We're honoring people who are outstanding in their field, both culturally and also supporters and advocates. Again, you can go to asiwny.org and find out about that. It's June 25th at the Hotel Lafayette. One of the other things that we do is we serve on a lot of committees and boards and such, and one of the things we're serving on right now is an initiative out of the New York State Attorney General's office called Charity Strong. It's something you're going to be hearing a lot more about in the months to come. It's sort of a matchmaking service between nonprofit organizations that are looking for growth in their boards, especially highly trained board members, and businesses and other organizations that want to place their employees on boards of directors. And so it's going to be piloted next year in 2 communities, New York City and the Buffalo area. And so United Way and some of the foundations and Art Services Initiative and a number of other folks are serving on that steering committee. And certainly by you being in this room tonight, you're on our list. And so when we start to reach out for organizations to participate, we'll be looking to all of you if you're interested. So with that, I'd like to introduce tonight's program. And we have 2 speakers from Hodgson Russ who are going to talk, as I said, about board governance issues. We have Kenneth Friedman, who's a partner at the firm. He's the leader of the firm's business practice area and its corporate and securities practice group. He concentrates his practice in mergers and acquisitions, corporate finance, business planning, nonprofit law, project finance and securities, and handles a broad range of general business matters. He is connected to the cultural sector. He's on the Board of Governors, on the Executive Committee, and Secretary of the Shaw Festival. He's a member of the Board of Trustees and Vice Chairman of the Buffalo History Museum, so now you know how we got the room. He's a member of the Board of Directors and Secretary of Western New York Technology Development Center, and on the boards of the Friends of the Buffalo Story, which is the group that has developed historic programming at Canal Side. An emeritus board member of the Board of Trustees of National Federation of Just Communities. There's about another paragraph and a half of past boards he served on, so he certainly knows his topic here. We also have Patricia Sandison, who's a member of the firm's corporate and securities and nonprofit law practice groups. She focuses her practice on nonprofit law, with particular emphasis on issues involving formation of nonprofit organizations, obtaining and maintaining tax-exempt status, intermediate sanctions, donor-advised funds, board governance, joint ventures, mergers, and restructuring. So all of the things we need to know more about. And she's a member of the Board of Directors of the International Institute of Buffalo, and an advisory board member of Buffalo Niagara 360, which is out of the Buffalo Niagara Partnership, and a board member of SUNY Buffalo Law School graduates of the last decade, which is called the Gold Group, which sounds like a group we all want to fundraise from. So with that, I will hand it over to Mr. Friedman and Ms. Sandison. Thank you very much for being here.
Hopefully that you can hear. Thank you for having us. And not-for-profit practice for us at Hodgson Russ is very, very important for a whole variety of reasons, but one of the biggest is we feel strongly and passionately about the community, and we feel strongly about all that you do for the not-for-profit community as well. So I think we all view that we're in this together to support the community. It isn't easy. Work on not-for-profit boards is sometimes fun, sometimes worthwhile, but sometimes it's very difficult, it's very challenging, and if you don't pay attention, sometimes you can take on some risks that you really didn't intend. Our job today, hopefully, is to give you some basics about board governance. You'll see a screen up there about the Non-for-Profit Revitalization Act. Board governance today necessarily is related to the new act that goes into effect July 1. You can't possibly talk about one without the other. And I know that there is another workshop coming up that's designed for that. Sorry if it's a little repetitive, but to talk about board governance today without understanding that really would be wasting of your time, because you need to know a little bit about it. But we also want to make this interactive. We both have a good deal of board experience. I was the president of this organization for many, many years. We went through some tough times and some terrific times. We're in the terrific times now, so I have the benefit of participating in that on a board from both a board member and the president of an organization. If you have questions about what to do or what are your thoughts, that's part of what this is about. I've also bring a perspective that very few in this community have. I happen to have been on a board that was written up in the Buffalo News as the most well-run board in Western New York, and the executive director was written up as the Citizen of the Year. I think it was 2 years in a row as the most well-run Citizen of the Year one time. January, we had a balanced budget. Not only did we have a perfect audit and a perfect review, we got an A from our auditors to say, you are the A team. You've done better than anyone they've ever seen. We were out of business in July, and in July they didn't make payroll. We had to place 40 Alzheimer's patients, 60 daycare placements, and had to deal with about 4 or 5 or 6 locations that were going to go out of business. So in a matter of 6 months, by the way, it was a who's who board. We had the head of the Federal Reserve, the president of several banks. It was perfect. We were out of business in 6 months. So if you have questions about lessons learned, happy to give you some thoughts. So we're going to talk about board governance and the Not-for-Profit Revitalization Act because they go together. We're not going to give you a preview of next week. We provided you with 2 handouts. One is called Overview for Directors of Not-for-Profit Corporations. That's not on the screen. And on the screen is the Revitalization Act. So they're both worthwhile to have. You can take some notes, but please, if you have questions, there is no question that is a bad question. I tell my kids that too, and it's true. A couple of very basics for those that, by the way, can I take a quick survey? How many are board members of organizations? So that, and how many aren't? So it's more than half are board members. Is your biggest things you're concerned about best practices? Is it about what liability do I have? Can they take away my furniture if I make a mistake? What are some of the most important things that we don't want to miss?
We want to stay out of jail.
We want to stay out of jail. That's a good one.
The compliance is the issue.
Excuse me? Compliance. So if somebody has check writing authority, are they worried that somehow they get a personal liability? Answer, yes. They don't want to scare anybody. But we'll try to focus. But if we don't cover something, ask. Because we're trying to do it on a relatively high level. But there are some details you have to know. But if we get too far down in the weeds, just stop us. Big picture, most of your organizations are formed under New York law. There's a thing called the New York Not-for-Profit Corporation Law, and hopefully somebody, a lawyer or some knowledgeable person, formed your organization as a not-for-profit corporation under the law. And the only difference between between the not-for-profit corporation law and the for-profit corporation law. It's a different law, but it's the same thing. You are a New York entity. And as a New York entity, generally speaking, you've got some governing documents that tell you what you're supposed to do and what you're not supposed to do. One of them is your bylaws, and one is your certificate of incorporation. Just because you're a New York State not-for-profit corporation with bylaws and with a certificate of incorporation doesn't mean that you have tax-exempt status. To be able to have tax-exempt status, the New York not-for-profit corporation has to apply to the federal government and say, I want to file this form and I want to be treated on a tax-exempt, I want to be treated as a 501, typically C3, but there are other numbers. A lot of people think that being a New York not-for-profit corporation automatically gives you some unique status with respect to being able to receive charitable contributions, and the answer is it does not. There are many not-for-profit corporations around that do not have 501c3 or other tax-exempt status. So that's sort of a big picture, but from a board governance standpoint, if one of you gets on a board of directors, some of the questions you should ask, I'd like to see your certificate of incorporation. I hope all of you asked that question who were on the board when you first got on. You said, I'd like to see the certificate of incorporation. Raise your hand. I didn't either. I want to see the bylaws. Who asked? Okay, well, you're ahead of me. It's very important particularly with a not-for-profit. I know it sounds basic, but if you don't think to ask what the mission, what's written in the certificate of incorporation, and you look at it, it will tell you what is it able to do. All a not-for-profit corporation can do is what the certificate of incorporation says it can do. And so if you're on the board and you have your duties as a board member and someone says, we are going to do this, one of your questions should be, can we? Sounds silly and sounds basic. I can assure you that there are multiple not-for-profit corporations out there that do things they are not able to do. And so from a compliance standpoint, from the very most basic compliance standpoint, can you do it? If you have a certificate of incorporation, you'll be able to determine whether or not you can or can't do it. With respect to your bylaws, they are not and should not be thought of as my lawyer put together these bylaws. They're just a form. They are really not just a form typically. Some of your organizations might be 20 years old. Someone might not have looked at those bylaws, and they might say things that your standard operating procedures that you do at every board meeting, you can't do. I'm sure you've had people, and we'll talk about it in more detail, ask questions like, we don't have a quorum, but somebody sent a representative to sit in that director's spot. That's okay, right? What do you think?
No.
It's not okay. If your bylaw said it was okay, is it okay? No, it's not okay. There are certain things that directors can't. I'm not grading tests, by the way, but but it's important to look at what your bylaws require. And if there's something you need to do isn't permitted, fix it. And in terms of compliance, it's important. So that the basic governing documents, your certificate of incorporation, and your bylaws, all of that goes in conjunction with what New York state law says your obligations are. And if you go look at the New York not-for-profit corporation law, almost every sentence in every statute says something like, you must do this unless your certificate says otherwise. So if your certificate doesn't say otherwise, the place to look for what your duties are in the statute. So when somebody at a board meeting, if it ever gets contentious, says, this is what we have to do and this is why, well, the first place you should look is your certificate of incorporation. The second place is your bylaws. And if it doesn't tell you what to do, then you look at what the state law says. Big picture, because I'm only talking about some big picture basics, because Trish is going to really talk about all the important stuff. Generally speaking, not-for-profit corporations, unlike regular corporations, don't really have owners. They don't have a stockholder, typically. A for-profit corporation, it's easy to figure out. The business of a for-profit corporation is to make money for the stockholders. It's really easy. The decisions that are made are really driven by stockholders who should make a profit. In a not-for-profit world, that isn't what drives the board of directors. The mission does. So if you look at what we're supposed to do, what guides your decisions, what your certificate of incorporation says is your mission. Most of the organizations that you're involved with probably have something called members. And a member could be a real member, because there are corporations that are owned by have members, and then there are those that think they have members, but they really don't. They just have people who pay to be part of it, and the board is really what runs the organization, and it's called a self-perpetuating board, and there really isn't. People have annual meetings and all kinds of stuff, but they mean relatively little. How would you find out what you are? You would look at your certificate of incorporation, and it would say, we're a member corporation, or it used to say a type A, or a type B, or a type C. But at the end of the day, a not-for-profit corporation is really a little different than a for-profit corporation. But the rules really are set forth in New York State law, in your bylaws, in your certificate, and in whatever policies, and we're going to talk about policies before.
So basically, you've got, as a New York not-for-profit corporation, which most of your organizations probably are, an alternative to a New York not-for-profit corporation is potentially a school, a museum that is created under the education law with a charter, but the New York not-for-profit corporation law will still apply in certain circumstances to those types of entities. But for organizations that are real live New York not-for-profit corporations, they are subject to New York State law, as Ken just covered. And then as a secondary tier of regulation, if you are a 501c3 or 501c4, whatever, what have you, for your tax-exempt status, you are then subject to this whole other regulatory scheme that is the IRS and its rules. So there really are two schemes that we need to keep in mind and kind of keep separate. So the bylaws and the certificate of incorporation that Ken just talked about, that is a state law concept that is all governed through New York State law, and you've filed your certificate of incorporation with the Secretary of State, and that's what you've told New York State you're going to be. So the purposes clause in your certificate of incorporation, that is the first place to look, as Ken mentioned, to know what's our mission, what were we formed to do. That is what you've told New York State, what you've told the Office of the Attorney General, this is what we're going to do, and they're going to hold you within that orbit of activities. So it's very important that as a director on the board, that you avoid things like mission creep. You know, a lot of times, particularly in light of the recent recession, we chase dollars, you know, whatever grant comes through just to make payroll, just to survive. But sometimes that unintended consequence of that is mission creep, where you've over time slowly diverted away from what your original purposes were. And if that's the case, that is something that is amendable. We can amend the certificate of incorporation, but it is something that we would have to file with the state. And then the second portion of that is then we have to go back to the IRS and say, hey, that application that we filed to be a tax-exempt organization, we said we would be doing all these activities. We're now coming back to you to tell you we're also doing all these. Are we still considered to be 501c3 tax-exempt organization from the IRS's perspective? So there are these two schemes to keep in mind, and we kind of have to pander to both beasts, so to speak. So in this outline we have on the director duties, the overview.
Would be the one, the overview for directors. If you look at page 3, the board of directors of not-for-profit corporations, that's where you guys are. And compliance was a question.
Yeah, and And so that's what we'll focus on here. And so from a legal perspective, this really covers what your role as a director is and will be under the state law. There are really three duties that we will cover. It's the duty of care, duty of obedience, and the duty of loyalty that you need to keep in mind. And these are what really encompass your fiduciary duties as directors. When people bring that up, those are the three that they mean. As a director on the board of directors, you are, as an individual director, have no power whatsoever to take any action. The only action that would be taken, obviously, is by vote of the board. You need to, at all times, operate as a whole. The board needs to take a vote and decide how they're going to disseminate a message. And so, if you think of yourself as a piece, one part of the whole, things like confidentiality and making certain announcements maybe before it would be in the best interest of the corporation as you go out into the community. It's something to keep in mind that really should be coming from the board as a whole, whether it's by the chair or the executive director in a very purposeful way. Your board has to have at least 3 directors. And if you're an education corporation, like a university or a college or even a school locally, you have to have between 5 and 25 trustees. And in certain circumstances, the Department of Education can let you have more, or can purposely say you can have more. I have a list in here of all the things that the board can not delegate to a committee setting, and this list in Section HC are those types of things that the board as a whole needs to take a vote on. You can't just throw it to a committee and say, hey, handle the amendment of the bylaws, or hey, handle that amendment of the certificate. These are like those key type of votes that the whole board needs to weigh in on. It's not something that you can just choose 3 people, convene a committee, and have them run with it.
When we use the word delegation, everyone understand delegating authority means to say, I'm going to delegate the authority to somebody else to do. These things you can't do that. These are the things that only the board can do, acting as a board in the way the bylaws say they would act. So if the bylaws say the board can act by a majority, one of the questions is, what does that mean? Does that mean a majority of all the board members, or does that mean a majority of just the board members that show up at a meeting that have enough to be a quorum? That's a tough question. If the bylaws don't say, the answer is it's a majority of the board. So, when you get down to questions about delegation and carrying out duties, it's important to understand how the board functions. And a set of bylaws could say the board can only act with 2/3 vote, for example, to sell real estate. It would not be an unusual thing. It used to be state law, well, still is. But there are, depending on what the rules say or the actions that need to be taken, tells you how the board can act, how many does it take, when a meeting is properly called, and all of that. But these are important.
Basically your duties as a director, your fiduciary duties, the first one is duty of care. This really comes down to, it's not your role to show up once a month and just rubber stamp everything the executive director may give you. This is, as a director, you have a duty to discharge your responsibilities in good faith and with a degree of diligence, care, and skill that an ordinarily prudent person would exercise under similar circumstances and like positions. I think the lawyer probably wrote that. But essentially what that means is you need to be engaged. You need to really think about it. And as votes come up, you really need to say, is this in the best interest of the organization? Is this something that we need more information about so we can make an informed decision on it? The law does not penalize directors for any incorrect decision that it may make, because everything's easier in retrospect after things blow up. But to the extent that you can show in minutes and in meetings that you really did take the time to think about it and have some sort of judgment to your decision and reason behind it, that's going to help you.
So, all kidding aside, when I said, do you have liability for writing a check? If you were writing a big check for the size of your organization, say your organization has a reasonable let's say a $10,000 check, is a big check. If you were to sign that check and not have it looked what it was for, who it went to, whether it was authorized, that's, that's not being engaged. That's not following your duty of care. I'm not talking about buying a sprinkler system. I'm talking about if you have something that's important to the organization, and you do not choose to take advantage of the opportunity to ask questions and understand it, you are not exhibiting the duty of care. And from a compliance standpoint, you could have liability. So this is a lesson from my board experience. If you go to a board meeting and the financials aren't there for 1 month, that could happen. It's possible. 2 months, that's not good. As a board member, you simply must insist that you have a reasonable amount of information about the organization on which you are serving on the board. And it doesn't have to be audited statements. The organization may not be big enough to have audited statements. But if you don't have something given to you by the executive director or the staff that you can rely on, you don't ask for it, that's not living up to your duty of care. Three times or 4 times, it's time to get off the board. I hope that doesn't sound too harsh, but it's important. You need to be engaged. You cannot be a rubber stamp.
And I have also put a note in there to quell any real fears of the practical effects of potential, liability that may come your way. I think from a judicial perspective, any judicial inquiry that has happened that we've seen for a breach of duty of care in this context, it has to be really bad faith or willful self-dealing. So the courts know that you're volunteer directors on a board and you're doing the best you can with the time you've given to the project, but still, as far as fiduciary obligations are concerned and your good faith efforts, this is really the standard we're all aspiring to. Duty of loyalty is the second one, and the core of this comes down to you need to put the interests of the corporation before those of your own or before those of your business or anything else. Ultimately, when you're making a decision as a director, the question to ask yourself is this in the corporation's best interest? Also, under the new law, which you have a very comprehensive summary of in this other handout, there is now a concept of related party transactions, which makes it very clear that for certain transactions that involve directors or other insiders, the very inquiry that the board has to take a vote on in order to pass those types of things. For example, having the organization enter into a lease where the landlord is one of the directors and he would be receiving rent from the organization that may or may not be fair market value, that type of vote to ensure that the organization is getting the best deal it could possibly get from that transaction has to be taken with the best interests of the organization in mind. And the explicit vote the board would have to take is that it's fair, the transaction is reasonable, and it's in the best interest of organizations. So obviously hand in hand with that is that the law prohibits self-dealing. Anytime your objective for joining a board is to potentially funnel business to your for-profit business that you own, that's probably not a good sign, and it certainly isn't looked upon favorably by the AG.
But this stuff happens unintentionally. You may have an organization that's in need of a vehicle. Somebody wants to donate a vehicle, and that vehicle is desperately needed to, whether it's transport people or maybe to get people to different places, and it's going to be a great thing. One of your board members says, I got one. He or she will donate the vehicle and going to take this huge tax, try to take some kind of tax deduction. She's doing a good deed, and the organization is going to give a receipt. Think about the implications of that. There are rules that you should very carefully consider. I know it's a good deed, and I know the organization needs the vehicle, but at the end of the day, there is an element of self-dealing in it that needs to be addressed, thought about, and dealt with. So these are not abstract ideas. If you're serving on a board, and even in spite of people's best intentions, if there is a relationship between the board and the organization, I don't mean you can't do it. It just means you have to have your thinking cap on and say, oh, better be careful, better make sure that we've thought about it so that we make sure we cover our bases. Or maybe they don't take away your furniture, like my irreverent joke would be, but you might lose your tax exempt status as a result of not paying attention to those things.
So whereas charitable contributions are more rare circumstance for that, another example that seems innocuous that may not be is anytime the organization needs office supplies or something and a director owns an office supply business, he's going to sell the office supplies to the organization at cost. I mean, it couldn't possibly get cheaper than that cost, right? Still, it's the board's obligation to be sure that if they didn't go down the street to Staples, his at-cost value is not higher than what you could get at Staples or some other bargain store. So it's stuff like that that seems like it's totally harmless, but both from the IRS's perspective and now when making this new law from the AG's perspective as a state law concept are going to be a little bit more scrutinized.
And the only reason we bring this stuff up, you might be thinking to yourself, how could this ever be a problem? Who would ever say anything? Well, in Buffalo, it's national sport to see board members sort of get mad and object. And when they object, they tattle and they tell us, they say stuff and they do stuff that no one would ever thought. I mean, you're watching school boards going goofy and, out in the suburbs, people get told, you didn't tell, egging car, I mean, that's what they do about it. That's what we do. It's a great sport. So it's important that you do your best on this stuff. And so the example that Trish gave about buying office supplies, it would be nothing to simply document somewhere that we very much thank board member X for the kind and generous contribution, whatever you want to call it. And in addition, we checked at these other locations, and we found that the donation is so terrific because it's going to save us. It doesn't have to be mean and nasty and legal. It's just using good judgment that the board and the director that's involved are working at arm's length, and it is what it purports to be. So if somebody were to object later, at least you have a contemporaneous record of what happened, why it happened, and in most cases, it works just fine, even if there is, I don't say self-dealing, even if there is people who are related.
So I use the word self-dealing, but really what it comes down to is an excess benefit. Any sort of benefit that a director would get in excess of what would otherwise be a reasonable price or a reasonable deal at the expense of the organization. The flip side of that is if the organization gets something for free and they're getting an excess benefit, that's fine. We like that. That is perfectly fine. Hand in hand with your duty of loyalty, obviously, is confidentiality. As a director on the board, anything that happens in those board meetings is confidential, aside from when the board itself decides how they're going to emanate or disseminate that information and issue a press release or what have you. So that's just something to go back to your boards and really stress, because sometimes having certain information leaks given certain sensitivities can be very damaging to your organization.
Is there a question? I think I saw a hand go up. Is there a question? Okay.
If there is, just yell out.
I thought there was. Sorry.
No, that's fine. The third one is your duty of obedience, which sounds a little bit like dog training school or something, but really what that one boils down to is, follow the law, try to follow your bylaws, try to make sure that everything you do are well in line with the policies that the organization has adopted, and you should be fine. And that the organization's assets and money are really being spent for the organization's purpose and not for some other interest. So Ken had mentioned that for nonprofits, they really are quite similar to for-profits, but for this whole concept of shareholders. So really, who are your organizations accountable to? As far as the state and IRS are concerned, directors have a responsibility to the corporation itself and its interests to further its mission, but really the constituency that your organizations are serving is the community. And the community is giving you money to hold in trust and to spend for the purpose of furthering your mission to benefit the community. So anytime that money goes to some other sort of end, it's going to be a problem. And part of that community, which includes the full public at large, but it also could include your particular clients. If you are an organization that, serves the visually impaired, they're going to be your constituency that you'll have an obligation towards. And then if you have members, real members that, for instance, have the ability to elect the board, obviously that is somebody you also have an obligation to, and those members have affirmative rights that you have to be sure that you understand in the bylaws and administer properly. So, let's see. In here, there's a sprinkling of other things that I think may be of interest, particularly special requirements in the financial arena. A lot of this is, how to, monitor certain gifts. If a donor gives a gift and says, I'm giving you this gift to build a section of your museum, that addresses primates or something, which I have a special affinity for, that is an earmarked type of gift. That is something that is restricted by the donor and something that, upon acceptance by the organization has an obligation to ensure that the money is spent as the donor wished. So that type of thing is something that the board should be concerned about as well.
There's a couple things that are worth, because I think if you look at director responsibility and procedures, just going to hit a couple because I know that I get asked about these all the time, and at the risk of being repetitive. As a board member, your job is to attend meetings regularly. Your duty of care you don't live up to your duty of care only making half the meetings. Your responsibility is to be prepared to go to a meeting and to know what's happening. All of those things are what a board member should do, and if you're the president of the board, you should be making sure that you tell your board members this is what you expect of a board member. Good communication, it's really good stuff, and it's important. You should have somebody take good minutes, and people should read them. The minutes are important. They will get looked at some point, whether it's in the context of.
Just to clarify the issue of confidentiality and board minute taking, are things that discussed just not recorded, or do you have to record them in a different way, in some way, shape, or form?
I'm not sure I understand.
Well, I think it comes down to who is able to see your minutes. If for some reason they're foilable, or you have open meeting laws that apply to you, whether you're in the SUNY system or what have you, and there are other rules you're taking into mind, there's a little bit of a dance that could go on in just making sure that the minutes are reflecting things in the proper light. If you are just a normal vanilla not-for-profit operating in Buffalo as a C3, those minutes really are part of the record and really only the board's eyes. I do have clients that say to them, that have made the decision that they want to be fully transparent to their staff, and so minutes are circulated, but before they are, it's taken into consideration if there are any highly sensitive things that have been discussed, and that would be redacted out, potentially if it's something that's unresolved or could create more drama than intended. But the minutes really are the internal record of what was discussed, how it was considered, and it really is there to protect you, and to the extent anybody throws any sort of rope into question, you want to be able to refer to them.
But keep in mind, there's no book that's going to tell someone how to keep minutes, absent open meetings law and things of that sort. So if your board is having a discussion,
You don't need, and I would recommend that you don't, unless there is something unique about your organization. You don't need to say, Fred said this, Joanne said this, and Diane said that. That's not really, that's dictation. That's not what minutes are. It's okay to say an enthusiastic discussion followed on the merits of whether or not we should hire a new executive director. You know, I would encourage you not to say things like, we don't want that executive director because she's too old. You know, those would be bad things to say. You know, we don't hire that one because that person has a heart condition. Don't do that. But you're supposed to be documenting what you are doing, and think of what the outside world, if somebody were to see them, you would want to look like you know what you are doing. And it's perfectly fine to say a spirited discussion followed where all points were considered, everyone participated, and we decided after, you know, if we wanted to really show how long, after a 20-minute discussion, you know, we decided to do this. I mean, if you know, do you have to say, and you know, it's okay to say in your minutes, a motion made, properly seconded, it was approved. You don't need to say it was approved 5-2 unless there was some unique feature to it. You're simply making a record of what it is that you did and sort of why you did it without, you don't need more, you don't need less.
Aren't dissenting opinions, shouldn't they be noted?
You could, if there is something that a purpose would be served, then there's no reason not to. But let me ask, what would be, remember, the action that a board takes is an action that a board takes. So it is whether there's a dissent or not. If it's voted on, it's 5-4. And 4 people are now going to vote no. And they want their opinion in quote record. For what?
I mean, the only reason that that would be helpful is if it really is one of these particularly problematic things where 5 of the people are self-dealing or something and they've approved a transaction that you think is, and in which case it may not be the worst idea, but it wouldn't be something that, you know, for everyday plain vanilla votes you would, you know, go through the trouble of, unless you really thought, okay, hey, this could come back on me as a director. And just expanding on Ken's point about not attending meetings, the scary thing about not being there is that everything that happens in those meetings are imputed to you as a director, whether you were there or not. And you know, the next meeting, everybody reviews the meeting minutes of the prior meeting and approves them as, you know, hey, yeah, that was how I remembered it. And every time that happens and they're approved, they're in the record, and it's imputed to you. So
it's a really good question, though, and it's really important because it goes to the confidentiality part. As a board member, once a decision is made, truly your job is to support the decision made by the board, or frankly, get off, because it really is not the job of I mean, you don't have to agree with everything an organization does, but the one thing you shouldn't do to live up to your duty of care and loyalty is harm the organization. So, if you were to disagree with a decision, there are ways and things to do about disagreeing with that decision. But one is going out to the Buffalo News and saying, I disagree with that decision. That would really not be advancing the organization, in my view. If, though, the board wanted to keep track, you may, as a board member, may disagree and say, I want it in the record that I disagree. That happens all the time. No problem. I would recommend whoever's taking the minutes would say, so-and-so expressed his disagreement, this was why. Doesn't even have to have a name. There were three people over strenuous objections. But I would recommend that you not put in the record things that could be harmful. Something that would give a plaintiff's lawyer the opportunity to hurt the organization. See, so-and-so said, don't do this. The building's gonna explode. You know, I told you to get a new air conditioner. We didn't get, that air conditioner is gonna kill 3 people. You know, a bunch of people made a reasoned decision to not buy a new air conditioner. And he said, I told you that was gonna blow up. But the last thing you want is a piece of paper that gives a roadmap to somebody to hurt the organization. There are other ways to express that stuff. This comes from experience a lot. It's not the best place to engage in an extended disagreement in the record of the organization. Better off, that's why they have telephones, and that's why you have other places to do that. You read about it in the paper every day, and I can't tell you how strongly I encourage you to remind board members that they got to keep confidential. The organizations cannot continue when 1 or 2 board members, you know, they tell stuff 2 minutes after something happens. And I've been on boards of private schools where decisions are made, and all of a sudden teachers find out that they're going to lose their job before even the decision was made. It's because some board member like one of the teachers. I mean, it's very, very tough, but your responsibility, your duty of care, duty of loyalty, and duty of obedience require you to leave your personal agendas at the door. If you don't, you're not really, yes, you have to have passion for the organization, but you also have to live and work and play in the sandbox.
And to the extent this drama ever does occur, when it does, it also ties back to this duty of obedience for, was the meeting properly called? You know, was there a quorum? Were any of these directors properly elected? You know, once you have all this drama, if you have one bad egg that's going to try to overturn everything that the board's done, or to try to, you know, if you try to remove a director, for instance, who's going to come back, and those are the first place somebody goes when there's an issue is the bylaws, to be sure that there weren't any loopholes that they can exploit for their own cause. So anytime there's a you know, fissure or any sort of conflict of that nature, that is when it comes right back down to, hey, how can I poke a hole into this? And so that is one reason to get on top of your bylaws now, to be sure that votes are taken properly and the proper quorum's there, just so you can protect the organization from that type of hassle, because it happens.
Also want to make sure we cover a couple things that I know come up all the time, especially in organizations that are, I think, that are here, just so that you're aware. You may already know this, but generally speaking, a board member may not delegate his duty to anyone else. So if a board member can't be at a meeting, not much you can do about it. You can't send a replacement. That doesn't work. Boards act either by vote, or they can act by something called unanimous consent. Unanimous consent requires how many? Everyone. Not everyone who's there, everyone. So that means a piece of paper, a writing where everyone signs. How do you get that piece of paper signed by everyone? Well, you can circulate it around and everybody can sign it. You have some clarity now. You can do that by email now. That's clear. It didn't used to be clear. Well, it will be clear. It will be clear July 1, but it's probably okay. A writing is a writing. You know, it's probably okay now. But July 1, a writing it counts as an email. I mean, it's an email.
Which is basically, Ken Friedman sending an email from his account saying, I agree to this vote. Send. Not PDF the signature page and send it, which currently is available or possible, but as of July 1, you can actually have.
If your bylaws permit you to have a telephone meeting, that's another way around doing this, but just so you know the basics, telephone meetings require something important. Everyone has to be able to hear each other. So it can't just mean it could be a web thing, but the requirement, you don't have to see each other. But if I'm arguing with Trish and we're on the board together, she's got to be able to hear me arguing, and I got to be able to hear her. Everyone's got to be able to hear, and then hopefully, then if you want to take a vote and that kind of thing, that works just fine. But a unanimous consent needs to be unanimous. A telephone meeting or other meeting doesn't, the decision doesn't need to be unanimous. You need to have a quorum, and then typically you need a majority of the quorum. That's unless there's some other rules other than that. Other quick basic, oops, I'm sorry.
Well, related to this, I've got an issue right now. We're between board meetings, and we have to make a decision about something, so we need to do it electronically, by unanimous written consent.
Right.
Right.
But I've got a board member who's gone AWOL, and my bylaws won't permit me to consider that he's resigned until the next board meeting.
Something
What do
that's
I do?
helpful in a situation like that is, if it's a vote that can be taken by an executive committee, an executive committee typically has all the powers of the board for these very purposes. So if you have an emergency situation that you need to take a vote on, the members of the executive committee can convene rather than trying to pull the whole board together. So that's an option.
You have
So
an
I can
executive-
rely on just what we call our steering committee.
If your governing documents say you have an executive committee that has the authority, if you have, it's not unusual for a board and bylaws to permit the formation of an executive committee that would be all have all the authority in between meetings. However, just because this always gets asked,
Okay,
who can be a member of the executive committee? No question, only board members.
Okay.
You can't be
We have a steering committee, it's in our constitution, and this helps. My problem is solved. Except in my case, this particular member is not on the steering committee. What if he were?
If you were, you would be convening a meeting of the steering committee, so you'd only need a quorum to take the vote.
Okay.
So and you only need a unanimous vote if it's by written consent. And the written consent is, you could do a written consent of the executive committee if no one can actually get into the same room, or you can do a written consent of the full board. But anytime you're doing it by written consent, every single director or committee member needs to sign.
But I would ask you, has he gone AWOL because he's mad, or he's just gone AWOL because he can't find it?
Well, it's hard to tell for certain because you can't talk to him. But,
This is very common, I mean, this is not an unusual, this is the kind of thing that happens all over the place, which is why when you are forming, if you can look at your bylaws while everybody's happy and solve these issues while everybody's happy, nobody will care. So you should have an executive committee that has all the authority on the board in between meetings to take all actions. That works. But just so we don't forget, who can be members of what committees, the new law, which hopefully we can cover some of the important stuff. There are two different kinds of activities. If a committee that's delegated the authority of the board, like the executive committee, something that's going to do something, can only have board members on it. Okay? But a committee that isn't going to it's not going to have delegated authority, but it's going to be more advisory. So like a marketing committee or a communications committee.
Party planning.
That committee can have non-board members because they're not binding the corporation. They are advising the board, and the board will take action. They can have non-board members. The new law is pretty clear, though, on this topic, and we're not going to let it until we at least cover a couple of concepts of the new law. Because we need to.
that's my second question is this. What if I have a board that has all board members? What if I have a committee that has all board members on it? But the intent is to have some non-board members on it.
Well,
Is that a committee of the corporation? Is that a committee of
The
the
committee's only as good as what delegated powers it's got. So when the board actually convenes the committee or appoints the committee members to, and creates a committee, it's gonna be, we're creating this committee to do X. And X is their mandate, and they cannot operate outside of what the board has given them power to do.
But it would be okay if you wanted to form an executive committee that would have non-members on it. They just can't vote. So long as you live up, I don't want to it could get sticky with confidentiality and all this other stuff, but the general matter, what they're focusing on is you can't delegate the authority that a director has to take actions on behalf of the corporation, you must have the fiduciary duty that a director has, duty of care, duty of loyalty, duty of obedience. Non-board members don't have that. And because they don't have that, in theory, they're not behaving with that same level of care that someone. Well, I know that sounds legal, but that's what this is.
And by virtue of that, you don't have the excuse to say, well, I told these guys to go and run with it, I can't help if they made a bad decision, because it still comes back. Yeah?
One other question about this fellow's question. If an executive board does, in an interim like that between meetings, make a decision, does that have to be ratified by the full board?
It's a great question, and I would love, here's what I would, my guess is if I went and looked at his board, his bylaws, they probably don't give the steering committee the kind of authority that we're talking about, that we're talking about to delegate to an executive committee. So if the board, if the bylaws were to say something like the executive committee is delegated all the authority of the board in between meetings, and they don't need to have decisions ratified at the next meeting because they are delegated, blah, 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 blah.
And they can fully bind the board, yeah.
Then that's the kind of, if you have that, answer is no, don't need it. Absent that, and you have something that you're trying to get something done and you're doing the best you can, I'd ratify it.
And when in doubt, always ratify. It doesn't hurt, and it gets the full board up to speed on what happened in between the meetings. One caveat to this is on page 3 of that outline, which lists those types of votes that you cannot do in an executive committee setting, despite having the full green card to bind the board in interim meetings. So things like filling board or committee vacancies, it seems innocuous, but the statute requires the full board take that vote and so on. Same for amending bylaws, amending the certificate of name, because you don't want an executive committee to go and change your purposes of the organization. You know, these are kind of like those big ticket items that the full board really needs to weigh in as a full vote.
There's a section on director and officer liability on page 6 and 7, and I would encourage you to look at that because there are common questions that come up. But one of them is, when can you be personally liable? We've listed the 5 items where you can be personally liable. Probably worth looking at. These are the words that you, when you hear something like, we may not be able to make payroll, if you take action knowing that you're going to ask people to go to work and you don't have the funds to pay them, that's more than a signal. Yes, if push comes to shove, you can have personal liabilities. If you hear you don't have money to make payroll, don't ask someone to work. I hope that, I'm just, obviously that's a summary of a lot of stuff. But at the end of the day, if you don't have the money, stop doing what you're doing, or get the money. But don't let somebody work expecting to be paid and then say, oops, sorry, knew I didn't have it. There is exposure. Another place where there is exposure, and there is some help here, but there is exposure. If you are the one with check writing authority, even though there's comfortable words, and yes, I've been in the role of check writing authority, and sometimes you got to do what you got to do. But when you have check writing authority, you should have that little extra care, because there can be personal liability. I don't want to overstate it, but I'm also saying don't blindly sign checks without at least asking, do we have the money? What's it for? And I'm on the board of some pretty big organizations where I have check writing authority, and even that I say, let me see the receipt, let me see what's it for. And it's not like I'm going to know if someone's going to pull the wool over my eyes. I'd be able to, but at least I asked.
So I know it's 7 o'clock and we don't want to keep you here longer than you anticipated being here, hold you hostage. We'll certainly be available at the end for questions. But just to touch on a few things on this new New York Nonprofit Revitalization Act. This is the first substantial overhaul of the New York Not-for-Profit Corporation Law in over 40 years. So it's really been the only real overhaul of the law. And so it's a big deal. It's finally gotten through, but the big caution I would say is that it really is, and it has to, just by its nature, take a one-size-fits-all approach. So anything from a small organization to, Kaleida Health or, huge hospital systems are going to be subject to the same types of requirements. The law applies to New York not-for-profit corporations. It applies to education corporations as well as religious corporations. It also applies to charitable trusts. So to the extent any of you are involved in private foundations that were formed as a charitable trust, you are not exempt from certain obligations under the new law. Basically, the goal here of passing this is to reduce unnecessary and outdated burdens on nonprofits, and also, and here's, I think, the major goal, particularly from the AG's perspective, is to enhance nonprofit governance and oversight to prevent fraud and to improve the public trust. And how the AG is looking to accomplish this is to put affirmative obligations that have in the past been viewed as best practices to be completely mandatory going forward. Examples of this would be, there are concepts, sorry, I'm kind of jumping around, so slide 7 is probably a good place. The highlights of the Act are independent director rules. There are now related party transaction rules. Every single nonprofit is required to adopt a conflict of interest policy, no matter what, whether you're type A, B, C, or D. Whistleblower policies are required of nonprofits that have 20 or more employees and have annual revenue in excess of $1 million. So if you trigger those two thresholds, you're going to have a whistleblower policy in place. And kind of a monster part of it is also these audit oversight rules and obligations. If you are a nonprofit that is registered in New York to solicit contributions, which I assume most of you are, and you meet the threshold for filing audit reports with the Attorney General, then you are going to be subject to the audit oversight rules.
If anybody gets any takeaway from this, these bullets are important takeaways. We'll hit a couple of highlights, but basically, if anyone were to go look at the Form 990, that your 501c3 organization, your 501c3, one of the last pages has a bunch of questions. And the questions you got to answer yes or no. And the questions say, do you have a conflict of interest policy? You don't want to answer, the only bad answer is no. So you'll adopt one.
And so that's probably why most of you already have a conflict of interest policy, because in the process of forming your nonprofit and making all these statements to the IRS, in light of these types of questions, which weren't a direct requirement, but certainly a strong recommendation, a lot of organizations have adopted the IRS form conflict of interest policy. But I caution you that that form IRS conflict of interest policy, you can't just check the box and say, great, we've got one, no problem. It doesn't exactly dovetail to what New York now requires for you to have in their idea of what a conflict of interest policy may be. So at very least, if you've got a conflict of interest policy already in place, I urge you to review it and just be sure that it also hits all the high marks of what is required under the law.
We've done a number of these. Well, Tricia's done way more than I have. We always get asked the same question: can you send us the form? And let me say, it's a great question. If you want the form, you're not carrying out your duty of care to the corporation. So if you were to, even though you were to take the form and look at it, at least put in your minutes, the board looked at the conflict of interest policy and went through it and concluded this is a good one. At least try. And I mean that. So in terms of anything that people perceive as forms now, the new rules that are out there are trying to say to you, don't look at it that way. You're supposed to read the stuff when you go to a meeting in advance. You're supposed to go, you're supposed to attend, and you're supposed to care. So is there a form? Sort of. Like Trish said, there's an IRS form. Does it work? No, it doesn't cover all the items that are required by New York. Is it close enough? Probably. Am I telling you to adopt that and it'll work? No, lawyers don't do that. But what I am saying is you should ask, what's the purpose of a conflict of interest policy, and does it work for your particular organization? A conflict of interest at a school might be different than a conflict of interest that might exist at an opera house, and it might be different than at a health and human services center. There could be different ways that people could have conflicts.
And to that very point, an interesting thing about the New York, this new act is it does not define conflict of interest for you. It leaves it to the organization itself to define for itself what it wants to view as a conflict of interest. So with one caveat, they have this whole other arena of things that they are calling related party transactions. They're treated as two separate animals under the Act, but if you read it all together, it's very clear that a related party transaction is considered to be a conflict of interest. It's just a subset of what might be the full universe of what your organization uses a conflict of interest. So if you've got a conflict of interest policy currently in place, I guarantee you it doesn't provide for the New York related party transaction rules because those are brand new. So at a bare minimum, you want to update it to reflect those rules. And I'm actually relieved that you're having a full presentation on this at your next session, because we really could be here for the whole day to talk about the depth of this rule, of what this act is requiring. But I can't stress enough that just because you have one doesn't mean it's fully compliant, except that the law does have some sort of escape hatch, safe harbor, that if you've got a conflict of interest policy, and this applies to whistleblower policies as well, if you have one in place that's substantially compliant, not defined, but however, the general gist is it's going to be okay. What substantially compliant means, I don't know. There could be an argument that if it completely neglects to mention these related party transactions when they were an explicit part of this law, it may not live up to that standard. One concept, there are three things that independent directors on the board have to solely handle. So that's audit oversight obligations, conflict of interest matters as they arise, which means the votes on the conflicts as they arise, the votes on the related party transactions as they arise, and whistleblower violations as they're reported. Those three buckets of activity have to be dealt with exclusively by independent directors.
There's a whole slide in what we
Slide
provide.
9, next slide, yeah.
This is what an independent director now is.
And I
This
can
is all
assure
brand
you,
new.
not
It's
for
all
the
brand
faint
new.
of heart. It's all brand new, but it casts a very wide net. So the real take-home of this definition is, essentially, if you are an employee of the organization, clearly you're not going to be considered an independent director. But this takes it so many steps further than that. If your relative is an employee, that means you yourself are not an independent director. If you have received in some way in the last 3 years $10,000 in direct compensation from the corporation or an affiliate of the organization that you're a board member of, you are not going to be an independent director. Even if your relative has, you will not be an independent director.
As a practical matter for all of the boards and all of you, when you're out on your board and everybody wants to have someone, hopefully a lawyer from a law firm or an accountant from an accounting firm or a banker, somebody that might add some unique value, whether it's for legal services, accounting services, money, all of those folks, to the extent there is a bank loan, legal fee paid, an accounting fee paid, you should be thinking of them as not independent. And what that means is they're not on the audit committee. And is that stupid? I hope if the Attorney General isn't listening. Of course it's stupid. But you, as on the board, you should at least walk out of here with the idea of thinking about who you need to have some independent directors. Listen, it not only is what's coming, by the way, there are services already starting that to provide independent directors for a fee. Someone will come on your board, you can pay them a fee, and they can assure you they're independent.
But not more than 10 grand houses.
But the takeaway here is conflicts of interest, related party transactions, independent directors are not necessarily new concepts. They've always been around. It's just now there's a new statute that's designed to prevent all of the fraud that went on. A lot of the scandals that happened were because of related party transactions. And where this came from wasn't bad.
how it got to where it got. Even the Attorney General locally, we had him in to talk. Even he said it's going to be a learning curve for everybody to get up to speed. They're not going to be acting as the independent director of police. However, over the next, year to 18 months, it's going to be important for you to at least make sure that you have independent directors and that you have an audit committee and you have a nice conflict of interest policy, perhaps have a whistleblower policy. There's no harm to having one. And then you try your best to pay attention to it. I'm sure they'll go into more detail. There's a lot more information on the slides.
Because the practical implication really is, if you have a situation where your CFO or somebody, in the management of the organization has been clearly, for example, taking money, stealing off the, and doctoring the books, so to speak. If you have a situation like that and it hits the press and then all of a sudden the AG is involved in investigating it, if you don't have an audit committee that has gotten through all the hoops and followed and shadowed the auditor in a way that the law requires, and the CFO himself, who's clearly not an independent director, is heading up the audit committee, it's going to look really bad. And I think that ultimately is what the backlash is here. And because people say to me, well, okay, so if we don't do this, really, what is the repercussion? And the repercussion is bad PR, and particularly, in a smaller community like ours, it has a real effect on the organization. Yeah.
I have a question. So, I'm the director of Hall Waltz, and we've never had the executive director or any other employee be a voting member of the board of directors. But I've been on panels, and I know a lot of organizations, like arts organizations, executive directors serve on their boards.
Yeah.
Is this going to? I mean, we're not doing it, and I never thought it was a good idea. I always thought it was better to have, executive director answers to the board that's a separate body. But I know that a lot of organizations have their executive director, maybe even their artistic directors, serve on their board.
And
Is that going to be prohibited now?
It's not prohibited, but they're certainly not going to be independent directors. And they certainly cannot do these three functions of conflict of interest, audit, and whistleblower. But that being said, what they also cannot do, because more often than not, when you've got a situation like that, the executive committee or the executive director is really managing the meetings, right? Because he or she has the bulk of what to report of what happened that month. And so sometimes those executive directors as employees also serve as chairs of the board or presidents of the board because they're leading these meetings. This law affirmatively says you cannot have an employee of the organization also serve as a chair. And basically what the law is trying to get at is you are the board and you're exactly to your point, you are managing the corporation. There needs to be some sort of a separation between what the ED is doing down here and what the board is overseeing up here. And so that's how they would.
Can you go to slide 36 and 37? So there's some helpful, there's a lot of takeaway lessons from here. We're not going to. So here, no one, starting as the date, no employee can serve as chair of the board or any other projects or responsibility. And the next one, July 1.
So this slide is essentially saying, also hand in hand with this, is if you are ever having a meeting or a deliberation on setting the compensation for the executive director in a board meeting, and that director's on the board and there, he or she needs to remove themselves, recuse themselves from both the deliberation and the vote. They can't kind of stare you down across the table while the board tries to deliberate the pros and cons. They really do need to fully remove themselves, and this law makes that explicit. We don't want any undue influence on that type of decision.
And you people I know are going to start focusing on what does it mean to be the chair? Is the chair the president? I mean, there's lots of questions. They're all going to be good questions, and everybody's going to be learning together. But at the end of the day, you're going to have some independent directors when in doubt with respect to things that appear to be conflicts or appear to be related party transactions. And we can come up with all kinds of goofy examples of how bizarre the statute is of what's a related party, so-and-so's uncle. That's not really, I mean, yes, it's a fact that that's what the rules say, but your job board is really to say, do we have enough independent directors? Do we have enough quality people? And are we making good decisions? And is there someone with some interest in it that we need to make sure it gets disclosed so that we have full and fair discussion about it, and the person who would benefit isn't in the room? I mean, it's not rocket science at the end of the day, but it requires some care. And so the issue you raised, should the executive director be a member of the board, that's really more of a business call. What is going to be clear is, if he's an employee getting paid, he can't be the chair of the board. That's clear. But although it doesn't say he can't be on the board, it just means he can't be chair. So whether you think it's good judgment or not, some people think it's a good idea. Some don't. I think most of the boards I've been on, the executive director is not a voting member of the board, but are at every meeting. But in many cases, there's executive sessions where they're considered staff, and they would then leave the board at certain parts. I know in Canada, on a board that's on the Canadian board, they take it much more seriously than is in the U.S. I mean, every portion there's a very, 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 every meeting there will be a portion when staff's gone, and it's just the board. I've not seen the boards in the U.S. be as pristine in that regard.
So to kind of summarize, go ahead.
If you were to form a new not-for-profit, and you were looking for the ideal model of an organization, taking into account the new changes in the law and the positions and the titles, where would you recommend one looks for an ideal model?
Yeah, I mean, again, it'll come back to there's no one-size-fits-all ideal model, right? It's what are your activities going to be? How many directors do you want to have on the board? Because, I mean, there are two schools of thought on whether you're going to actually conduct business by committee, which is essential if you've got a board of 45 people, right? Versus, is it a small board? Is it 3 directors? And what's going to work for those 3 directors to be able to manage, and launch the operation? So there really is no ideal that we can and, hand out. It really has to be a customized approach.
But if you were to look at best practices, the best practices, I would recommend that boards of directors be smaller, not larger, just as to avoid the issue that was raised here. I got somebody who went rogue and went AWOL. Typically, smaller boards are more engaged than larger boards. That doesn't have to be, but if you're looking for a best practice, smaller rather than larger, and people would say, oh, but we want more people to help us with fundraising, so we want it to be bigger. Right? Common thing. People who are being asked to participate for fundraising, generally speaking, may not be the ones who have the duty of care, duty of loyalty, duty of meetings, show up at meetings. So find another, I would suggest, if you can, find another way. If you're lucky enough to find an engaged person with money, that's terrific. But there aren't as many of those around Western New York as I think the organizations need. So I would say Western New York has gotten away, generally speaking, from having a board that does the work of the board and then a separate foundation that does fundraising. Although that is a model that some people use, but I think you need to be a bigger, more sophisticated organization to go that direction. So I would say smaller rather than larger. I would say have a board of committed people, even though they're not all, if you love them all to be wealthy. I think terrific communication up front and letting them know what your expectations are of them. As painful it is, if you expect a board member to contribute $2,000, $5,000, $10,000, whatever you expect, tell them. But don't have someone come on the board and you have an expectation that they're going to contribute 2 and they contribute 1 and then you're mad. It's not good. I mean, I can't tell you, it's like every organization I'm on is always mad in certain directions. They don't do anything. Well, probably they didn't know up front that they were supposed to give $5,000. Had you only told them, they wouldn't have shown up.
Or is it a really heavily working board? Is this something that's not just a meeting once a month? It's, a daily conversation, at least, and real deliverables, that type of stuff. The more communication up front, the better off you'll be in having a successful board operate, and people who purposely avail themselves to that level of commitment and are willing to meet that output. And to Ken's point on the smaller board, the flip side of that is, you know, if you only have 3 directors, 2 have to show up to every meeting at least, right? So it is a heavier load to bear with a fewer number of people, but there is probably a good balance, you know, somewhere depending on what they're doing. So what the takeaways are for this new law, like if you're sitting there saying, okay, I'm on an organization, there's this new law, it's, you know, you've given me a 50-page presentation. Page 44 of it summarizes the takeaway lessons, but I'll summarize it as this. Certainly you need to pull out your bylaws, review them and update them, both to take into account to properly reflect the fact that you can now do email signatures to consents, to properly put in the new related party transaction type of rules. Update your conflict of interest policy. If you don't have one, certainly you have to adopt one by July 1. And to the extent you have over $1 million in revenue and over 20 employees, you need to adopt or update your whistleblower policy to be in line with the requirements of the law, which are all in here. And on that whistleblower policy in particular, you also have an affirmative obligation to distribute that policy to directors, officers, employees, and all volunteers that provide quote substantial services. So that's also another affirmative obligation. The other obligation that relates to the conflict of interest policy, every single director every year needs to sign a conflict of interest statement that affirmatively affirms what their obligations are, or what their relationships are, and what conflicts that they're going to identify. And so that needs to happen both before you even elect a director for the first time, so right before its initial election, and then subsequently on an annual basis thereafter, every director needs to do it. Even though the conflict of interest policy needs to cover directors, officers, and key employees in what conflicts it manages, only the directors are actually required to submit that statement. So your cheat sheet's in the back there on page 44 and 45. On all the summary of takeaways, if you need a list of, okay, action items for an organization, how do we wrap our heads around this?
I asked you at the beginning, what should you ask for? Certificate of incorporation, bylaws. Another thing, you should at least inquire whether the board has considered, and we didn't really cover it, directors and officers liability insurance. The price has come down materially. Not every organization might want to use their funds for it. It would be at least worth asking your insurance person how much it costs, what does it cover, is it a good idea? Generally speaking, if the cost is reasonable and met all those with respect to your particular budget, but to not have the conversation with your insurance and to ask the question or to assume that it is too expensive is a mistake. And it is a worthwhile thing, and for those looking for board members, many people who have the wherewithal to be good board members won't serve on a board without being insurance. So it's worth at least asking the question and considering it.
Because if you are indemnified by your organization as a director, it's really not worth much. If at the end of the day, if something happens, there's no money to back that indemnification up.
I have a question on the D&O insurance.
Sure.
In your experience, is that something that insurance companies shy away from for some reason? Because I'm contacting 3 commercial insurance agents for a quote. And I noticed you mentioned that the price has come down, which is great news. I have not been able to get a quote on it. And
I can't answer why that would, I don't know why that would be. Are you in the skydiving?
No, we're a theater.
One thing I'll say, if any organizations are funded by the New York State Council on the Arts, that means as part of that funding package, you're a member of the New York Council of Nonprofits, NICON. NICON has an arm that can provide insurance and does so pretty reasonably in our experience, especially directors and officers. So if you are NISCA funded or otherwise a member of NICON, that's a first place. It's called Council Services Plus. But even if you're not, you might want to at least reach out to them, because I'm not sure
It's a
whether
good
they'll adopt someone else and give them a, you may have to pay a little higher rate, I don't know, but it's a good place to start, they specialize in nonprofits.
But I would ask, and I don't understand why someone wouldn't vote. In terms of looking at your documents, if you're not-for-profit older and you really haven't looked at them, many in the old days, I don't know, like when I was born, they didn't have exculpation or indemnification provisions in their certificates. Boards should now, where it says basically that a board member is indemnified to the fullest extent permitted by law, and that would dovetail in with the insurance. But it is a meaningful thing, because doing the right thing doesn't always mean there won't be litigation. And lawyers, I know I don't like lawyers, but any expression, anybody can sue anybody for anything, unfortunately, in the U.S. and in New York in particular, is pretty true. The consequence of a lawsuit is usually expense. And one of the benefits of D&O insurance, again, to the extent it's available, to the extent it wasn't fraud and everything else, to the extent it would be a legitimate set of circumstances that insurance might be there, one of the benefits perhaps is payment to cover the costs and expenses of defending the litigation itself. And that, in and of, is probably worth the phone call, just to see whether you can get it, whether you can afford it, whether it would make sense for the organization. Because sometimes it wouldn't, but to not check, I think would be.
And it'll also help you recruit board members. A lot of board members aren't going to agree to be on the board if they don't see that they are covered by D&O. But NICON's a good suggestion as a starting point for, who they, if they themselves can't provide it through that arm, who they would recommend.
So I hope with this, we didn't want to take away from your next presentation on all the details. However, they do go together. The materials that Trish and others at the firm put together are really very, very helpful in that they have every 4 pages or so takeaway lessons, and the design of the takeaways really are to look at those and do they apply to your organization? Because some may say, I'm not worried about this. On the other hand, it's, I didn't know that. I should pay attention. I should look into it. A lot of people are all worried about what it means. In many cases, this is a benefit. There are some things that are cleaned up that will help you with circulating, emails and stuff like that. A lot of it helps. And a lot of it is also in good common sense to help with the way you run the organization. And I don't also want to leave, when it comes to good governance, about compliance. Someone said it's about compliance. I urge all of your organizations, I really mean it as a board member, to inquire of your executive director or inquire of your CFO or somebody involved, do you have policies about who writes checks? Who counts the money? Who opens the bank accounts? It's worthwhile. Just ask the question, and if you don't, look at the size of your organization, and maybe if it's not already done, a check over $10,000 needs 3 signatures, a check over $5,000 needs 2. That may not fit with your organization, but I urge you to think about that stuff. And if to the extent, if you have a small organization, if you can help it, don't have the same person open the bank account, close the bank account, review the statements, write the checks, and reconcile the checks. If there's a way to not have that happen, I urge you, don't do that. That's not in the law. That's just plain common sense. If you look at virtually every problem that's happened in Western New York, it's something about that stuff. Whereas the fraud that happened is somebody could do it all. And I'm speaking from some experience. If somebody sees a bank account that has the balance at the beginning of the month, the same person look at it, it's a balance at the end of the month, but didn't see the activity all month long, he's writing checks to himself. And you say, I didn't know. Well, as a board member, should you have known? All I can tell you is if you at least ask the question during the happy times to say, I think we should, wouldn't it be nice? How do we do that? It's worth it.
Putting in place internal controls. And if we haven't given you enough incentive to review the bylaws and update them, an interesting thing came up in one of our prior seminars. A head of a private foundation mentioned that when organizations come to their foundation for grants and things, if typically, or a lot of the time, they'll request your bylaws. And if those bylaws were adopted in 1968 and haven't been touched since, it's not going to reflect very well in your organization. So if for nothing else, incentive on getting grants and looking like you're on top of these things, it really does help you fundraise for your organization.
Just in the spirit of improvement, wondering if you could just from your own personal involvement with nonprofit organizations, perhaps share with us what your ideal relationship would be with the leadership of the organization in which you serve.
That's a loaded question, but from my personal experience, the organization that I mentioned that had the difficulty, the head of it was one of my closest friends. I had to take his car away from him. So having too close a relationship is no fun. That probably wasn't what you asked. However, I can't tell you when something goes wrong how painful it really is. The executive director is the executive director. He runs the organization. It's their responsibility. The board of directors at its most fundamental level is in charge of hiring and firing the board as the executive director. Everything else is sort of gravy. So if you're on the board, your job is to help the executive director be successful. The executive director works for the board, reports to the board, and takes direction from the board. When the lines get crossed, it's really when boards become meddlesome. Or, in my view, boards cannot micromanage. Boards shouldn't micromanage. And the easiest ones to understand are academic institutions. The board of directors, even though they all love school and know how to read and write and think they're experts, the academic world, the academics think they are responsible for education. I think it's instructive. The board really isn't in the business of teaching kids. The school is in the business of teaching kids. The board's job is to hire and fire the executive director. If they don't like where the kids are getting into college, fire the executive director. They shouldn't be deciding whether to teach calculus and whether to have 2 physics courses and maybe teach Chinese. And that's what happens with academic boards. They want, but it's when boards micromanage a lot that relationship gets blurred. So when you're asking about improvement, my view is a board. I think Patricia mentioned to leave your personal agendas at the door. Part of your duty of loyalty, duty of care. Your job is to be stewards of the organization, support the mission, hire the best executive director you can, support him or her to the greatest extent you can, but let that person do his or her job. Don't every day say, I think you should do this and you should do that. Certainly offer. It's nice when there's an open line of communication. I think there can be many ways to help allow board members to have that communication. Maybe there is off-sites, maybe there are retreats, maybe there's strategic planning, but on a day-to-day basis, boards that think of themselves as running the organization are typically not as successful.
Yeah, I definitely agree with that. I think ultimately at the end of the day, the most success you're going to get is having both the executive director and the board of directors truly understand what their role is. That's going to help tremendously. If the board is operating as a nose in, hands out, that's typically the right approach. It's overseeing and management from the board level. It's not day-to-day operations and meddling. But, I've seen it both ways where the lines do get crossed and blurred. I've seen truly passive boards that have had a culture of being a truly passive board where the executive directors had no choice but to take the bull by the horns and make decisions because the board is really just a rubber stamp board that shows up every month and goes through the motions. And it's a truly interesting experience to see those types of boards, once they get proper members on that try to reassert the board's authority over the executive director. It can become one of these type of board things because you know, to the extent that you've got an executive director that's used to calling all the shots and not really answering to a well-managed oversight or well-managed board that's providing real oversight, it becomes problematic to change the turn the tide, I guess, and to change to have the board reassert that power. And to the same effect, if you've got a board that institutionally have always been overly meddlesome and really in the weeds, so to speak, in making management decisions, a lot of times that you could have an executive director for a 15-year stint that is a passive one that just takes the board's mandate and executes it as passively as
As an
possible.
executive director of an organization, do you agree with that or disagree?
Absolutely, yeah. I think that it's really about finding the balance. Just like you said, the executive committee sort of handles things when a board's not in session. The executive director is handling the day-to-day, and the board is helping set that overall policy, especially through the budget. The budget's the planning document for the next year. And so, I've served on a lot of boards myself too, and far too often, other than the 2 or 3 people on the finance committee crafting the budget, the board never takes a look at the budget. They just sort of get it, adopt it. Well, what they're adopting is the plan for programming. They're adopting the fundraising goals. They're adopting, the people, policies, and programs of the organization for the next year, and they don't pay attention to it. But then, during the course of the year, why are we doing this? Why are we doing this? What are we doing here? Well, they missed a prime opportunity to really inform that, and that leads to them feeling like they're not involved or engaged. But they missed the prime opportunity.
And then,
Sorry, I was a little bit.
That's exactly right.
But following on that, when you said on that, how do we improve or self-improvement, if you were to take the executive director's perspective and then say a quality executive director, though, empowers members of the board to get involved and help set the agenda. So it does work together. If the executive director is a kind of person that would say to board members, I want your input, I seek your input, and you feel empowered to provide that input, typically that's the most successful model where there is some engagement, but at the end of the day, the executive director runs the organization. If the board doesn't like him, get rid of the executive director. It's not about sort of having a puppet up there and do what the board says. Anything else? Because we let you go home and have a drink.
Thank you both very much. A couple of times it was mentioned our next session. So the next session is a session on the Nonprofit Revitalization Act. It's on Thursday, June 19th at 6 p.m. at the North Tonawanda Public Library. All of our sessions, all are welcome, staff and boards. A lot of what we do is sort of geared to staff, but it could be very useful for board members. So please, ASIWNY.org will post the materials from tonight. Get on our mailing list, like us on Facebook, and you'll learn about upcoming trainings throughout the year. Everything from how to get better press coverage to cash flow forecasting. In other words, all the boring stuff we really need to know in order to do the art really well. Thanks very much.